Hello everyone. As you know, immigration news changes almost daily, and these updates can impact your case, your family, or even your long-term future in the United States. Let's talk about the recent changes in public charge policies. For USCIS, the new public charge policy is a new proposed rule. For Department of State, meaning for consulates, this is immediate. This already went into effect. It is being implemented by both agencies, and let's see how it works out. USCIS's version of the public charge rule signals a major shift away from the 2022 framework, which is currently valid. Although the 2022 rule remains in effect until the proposal becomes final, the newly issued text shows DHS, Department of Homeland Security, intends to apply a much broader interpretation of the public charge. The proposed rule would give adjudicating officers significantly expanded discretion, meaning the Form I-864 Affidavit of Support, which shows that you have a sponsor, becomes only one factor among many rather than the primary determining element. Under the proposal, officers may consider a wide range of personal circumstances, including education, employment history, financial status, language ability, medical conditions, and the expected costs ongoing treatment. This includes evaluating whether an applicant can communicate in English and what kinds of medications or long-term medical needs the individual has. Although USCIS has not yet clarified exactly how medication use will be analyzed in practice. The proposed rule also suggests that more categories of immigrants could be subject to public charge review, raising concerns that groups traditionally exempt, such as asylees and refugees, may be evaluated more broadly in the future, though this is not yet finalized or confirmed. At the same time, the Department of State has issued immediate consular guidance requiring consular officers abroad to begin using the updated discretionary standards right away. As a result, even though the USCIS rule is only proposed, the OS has already instructed consulates to apply a broader totality of the circumstances review on public charge. Visa applicants should therefore expect tighter scrutiny of their health conditions, financial stability, education, language ability, and overall self-sufficiency, even if they have never received public benefits. Importantly, non-cash benefits such as Medicaid, not including long-term institutional care, SNAP, WIC, CHIP, and housing assistance do not automatically count against applicants, consistent with the current rule. But officers may still review the applicant's overall financial vulnerability and potential future reliance on government resources. Because both USCIS and Department of State are signaling stricter enforcement through expanded discretionary evaluation, applicants should prepare complete, organized financial documents, medical coverage records, and evidence of employability to avoid delays or negative findings. Here's my problem with the new proposed regulations. It gives such a broad discretion to the consulate officers and USCIS officers. Discretion is not bad, discretion is good. If you give too much discretion, the results, the adjudications may not be consistent. So that's the problem. While one person can go to the interview and get an approval, another person with similar set of circumstances and financial and health situation may get a denial based on the discretion of the other officer. So discretion is good when applied properly, but giving broad discretion in these applications could result in inconsistency that cannot be remedied later. There is a nationwide pause on immigration decisions for 19 countries as announced by the administration. The US government has placed a pause on all immigration decisions for nationals from 19 travel restricted countries. Affected case types include visas, asylum, adjustment of status, work permits, all other immigration benefits. The impacted countries are Afghanistan, Burma, Myanmar, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. This pause may cause major delays, additional evidence requests, and extended security screenings. Let's talk about the recent development on EB-5 fees. The EB-5 fees are lowered by court decision. USCIS recently attempted to implement a very large fee increase for all major EB-5 filings, raising the cost for Form I-529 from $3,675 to $11,000, for Form I-829 from $3,750 to $9,500, and Forms 956 and 956F from $17,800 to $47,000. Some of the fees I have given you is approximate. I didn't give the exact dollar amount, but you can see how big the increase is. So there was litigation about this, and a federal court has now vacated the 2024 fee rule and ordered USCIS to revert to the old lower fee schedule because USCIS did not comply with the rulemaking process. This means that as of now, all EB-5 investors and regional centers will continue paying the pre-increased fees until USCIS issues a new lawful final rule. In practical terms, EB-5 applicants currently benefit from significantly reduced filing costs, but should be prepared for future increases as USCIS is expected to re-propose a revised fee signature. Investors considering an EB-5 application should file soon under the current lower fee before a new rule is published and implemented. Let's talk a little bit about the F-1 visas and what USCIS is working on in the recent months. As you know, for F-1 visas, M-1 visas, and I visas, which is media representatives, upon your entry, you get a DS, duration of status, meaning as long as you continue your status within the US, you do not have to leave at a certain date. That means, unlike a tourist visa or an H-1B visa or an E-2 visa, an F-1 visa would allow you to stay in the US as long as you go to school. This is what USCIS is working on. They are trying to restrict this to 4 years. So if you enter with an F-1 visa, you will get a 4-year stay. And if you want to stay more than 4 years, then you would have to extend your visa status. I was recently at an immigration lawyers conference and I talked to somebody who used to work with USCIS, and he thinks that this is a terrible idea because USCIS doesn't have enough resources or people to adjudicate this many extension or change of status applications from F-1 visa holders. But this is imminent. USCIS is working on it. We will see how it plays out. Also want to share some news about the consular denials. It is important to note that with this administration, consular 214B denials have increased. What does that mean? As you know, if a consular officer denies a visa under 214B, which is you do not have enough ties with your own country, that denial is non-renewable. You cannot object to it, you cannot file a motion. So that's why this administration now instructs consular officers to deny the cases where they don't see the applicant fit on 214B, so there is no objection from the applicant. It is very important that you go to those interviews, especially tourist visa interviews and student visa interviews, very well prepared, very well dressed, and you should be able to explain yourself within 60 seconds or less. A few DHS updates. DHS terminated the TPS for Haiti. This means nationals from Haiti previously protected under TPS may no longer rely on that status. Individuals may need to explore alternative immigration paths or risk losing work authorization and protection from removal. So this affects family-sponsored visas, immigrant visas, diversity visas, and other categories. Cases may be delayed indefinitely as the US reviews policy and security concerns. In closing, I want to say, yes, it seems like there's a lot of recent developments and most of them seem to be against the immigrants in this country. But don't forget, immigration lawyers adapt all the time. In the recent conferences that I've been, this was the vibe. We have seen many difficult circumstances throughout the years. Yes, this is one of the most difficult times, but we always adapt. The green card applications are still being adjudicated. They are still being approved. Now immigrant visa applications are still being adjudicated. They are still approved. So you need to find the best strategy for you. You just need to prepare in advance more carefully. That's what changed. We will adapt. We will get the cases approved, hopefully. So thank you for watching today's update. I hope this breakdown helped you understand the latest immigration changes and how they may affect you or your loved ones. If you found this video helpful, please make sure to like, subscribe, and share it with anyone who might benefit from this information. If you have any questions, write it in the comments section and I will try to respond as fast as I can.